लय होते की एवढं लहाचा कच्चिवड्या घेते देड्याने पल्ला लांब झाले काय पाहिजे आता तुला बस
Sir, if you permit, shall we start with the session? I request you to switch on your video. Yes, sir. I, on behalf of Team Legal Expatriate, welcome you all to the 4th session of 7 days online certificate course on drafting of injunction matters, for which we are honored to have with us Honorable Advocate Nagesh Sood, sir. Sir has completed his LLB from Aligarh Muslim University in 1993 and LLM from Gujarat University in Environmental Law in 2010. He has completed his postgraduate program in Human Rights from Indian Institute of Human Rights, New Delhi. He has been practicing since 20 years and has also worked as additional public prosecutor during his period of advocacy. He has experience of being a panel advocate on State Bank of India, Central Bank of India, Union Bank of India, Indian Bank, National Insurance Company, and many more. He has a vast professional experience in banking and insurance cases, as well as in service and labor matters pertaining to all institutions. He has pursued public interest litigation against the polluting companies through which 11 villages were adversely affected due to the effluent released by the chemical industries in Kharijat Canal, pursuant to which High Court ordered the closure of polluting industries and had directed them to pay compensation for restoration and preservation of pollution committed by them. He has filed various public interest litigations and has been reported and has 90 judgments reported in his name. We are honored to have with us such an eminent persona for our today's session. Before handing over the session to sir, I would like to request all the participants to switch off their video and mute their audio so that it would not create any hindrance in the ongoing session. Over to you, sir.
Yeah, good evening, one and all. Thank you very much, ma'am, for your very overwhelming introduction. Just one correction. I've had an experience of now nearly 30 years in practicing law before the High Court as well as the Supreme Court. Today, the topic which has been given to me is about drafting of injunction suits. Now, I've prepared a little PPT for the same so that, I'm able to present it visually as well as through the vocal medium and make all of you understand as to what is an injunction, how we have to draft the applications, what is the difference between temporary injunctions and permanent injunction, so on and so forth. So let me take you to the PPT first, and then I will go slowly accordingly. Yes. Is it visible to everyone, the PPT?
Yes, sir, it is visible.
All right. So, let us understand about the origin and nature of law of injunctions. Origin of injunctions can be traced to equity jurisprudence, which was formulated in the Roman legal system. As we all know that we have borrowed a lot of jurisprudence from Roman law, and thereafter the same was incorporated in English legal system, and subsequently it has now become the part of Indian legal system. The law of injunction follows the dictum of ubi jus ibi remedium, which means that where there is a right, there is a remedy. The Specific Relief Act 1963 espouses various kinds of reliefs, and injunctions are one of them. Injunctions form a class of preventive reliefs. It is something we know that the courts prevent, or there is a bar which is created by the court, which is granted by the court in circumstances where pecuniary compensation, that means compensation in terms of money, is either not commensurate to the wrongful act that has already been caused, or is likely to be caused, or is altogether futile. Meaning thereby, when can the court would grant preventive relief? When it sees that the circumstances are such that even if a money is given by way of compensation, that would not commensurate, that would not be equal to the wrongful act committed by the other party. So it is a preventive relief. Now, injuncting reliefs in general are remedies of an equitable nature, and thus it is an act in personam and not in rem. Now, what is an act in personam? Act in personam is an act against the person. An act and not in rem. Rem means the property. So whatever the relief that would be granted by the court would be in terms of act in personam. So an order of an injunction may be issued by the court for and against individuals, public bodies, or even the state. So what are the basic characteristic features of injunction? An injunction has three characteristic features. Number one, it is a judicial process. Number two, the object obtained thereby is restraint and prevention, and in some cases, doing of certain acts. Number three is the thing restrained or prevented is a wrongful act. So these are the basic characteristics features of the injunction. Now, what is an injunction? An injunction is a preventive remedy granted to a party aggrieved by the acts of another party, thereby refrain the wrongdoers to pursue the acts performed by them to evade any further injury, and thus considers equity. An injunction is an order of the court granted for the purpose of restraining the doing, continuance or repetition by the person enjoined, his servants or agents of some wrongful act which constitutes an infringement of a legal or equitable right, as for instance, a breach of contract. So, meaning thereby that the injunction is an order of the court for the purpose of restraining, for stopping the another person for doing or continuously doing that act or repeating that act which the person is already doing. And also the restraint is against these servants. It necessarily need not be of that person, but these servants as well as the agents are also restrained from the wrongful act. What is the wrongful act? If somebody is doing an act which constitute and which amounts to infringement of my legal or equitable right, that will be restrained by the court by an order of injunction. So an injunction is merely a process by which court enforces equity. An injunction is an order of an equitable nature, restraining the person to whom it is directed from performing a specified action in a certain exceptional cases, which will be considered hereinafter, requiring him to perform a specified act. So it also amounts to an act which the court would mandate on that person that you please do this act, right? It necessarily does not restrain or stop that person to do an act. In exceptional circumstances, it would also amount to telling that person, come on, you go and do this act. So the court mandates that person that you would perform this act. Now, what is the difference between the permanent injunction or the interlocutory injunction, which we call as temporary injunction? The difference lies between them as to permanent injunctions, where the restraint is to last forever. The restraint by the court is you are permanently stopped and you would henceforth never ever do that act which is infringing the right of the plaintiff or the petitioner. Whereas the temporary injunctions, which are also known as interlocutory injunctions, may be granted at any stage of the suit and shall continue until specified time or further orders of the court. Now, why we call them as temporary injunctions? These are the injunctions which are given by the court for a temporary period, for a short period. It may be, the period may be specified, or it may be said by the court until the further order is granted or given modifying that order, this injunction would continue. So temporary injunctions are regulated by Code of Civil Procedure 1908, whereas the perpetual injunctions, which are the permanent form of injunctions, are governed by Specific Relief Act 1963. Now, what are the various kinds of injunctions? As I said, there are two kinds of injunctions, temporary and perpetual injunctions. Section 37 of the Specific Relief Act 1963 deals with temporary and perpetual injunctions. 37(1) states that temporary injunctions continue until a specific period of time or until the further orders of the court, and they may be granted by the courts at any stage of the suit. So the very clear the section clearly the section says that it will continue until a specific period of time. If the court says, yes, this injunction is granted till the next date, so the period is specified by the court, so the injunction would be operative till that period. Now, the court may say that until further orders, this injunction or this order would continue until any other order stopping or modifying that order is passed. This injunction would continue, and they may be granted by the court at any stage of the suit. It may be granted initially the moment the suit is instituted and it is taken up for hearing. The court may pass a restraint order, or it may pass an order after hearing both the parties, after issuance of notice, or whenever the court feels that yes, now the time is right to grant this injunction, because that would create an irreparable loss to the other side, the court may grant the injunction at any point of time during the pendency of the suit. So Order 39 rules 1 to 5 of the Code of Civil Procedure 1908 govern temporary injunctions. Temporary or preliminary or interim or interlocutory injunction, these are one and the same thing, continue till a specific time or until further orders of the court. They may be granted at any stage of a suit. In other words, they operate for a specific period when a suit, appeal, or any other proceeding is pending before the court of law. They do not conclude the rights and liabilities of the parties involved finally. So, when the liabilities and rights are finalized, that is at the end of the suit, when a decree is passed, that is where the liabilities are decided, the rights are decided finally. But until then, the court grants this interim or temporary relief so that further that infringement is not continued, or it is not causing that violation of rights of the plaintiff. So it therefore follows that a court can only pass an order of temporary injunction and not a decree. So decree is the final order of the court, final judgment of the court, whereas interim orders are passed during the interim period, that is interlocutory stage of the suit. So there are two cases which are important. One is Arudra Engineers Private Limited versus Patanjali Ayurved Limited is one of the latest examples of a case where the plaintiff filed an application under Rule 1 and 2 of Order 39 for an order of injunction in the Madras High Court. The plaintiff claimed that its registered trademark has been infringed by the defendant when the latter released Ayurvedic tablets called Coronil as an alleged cure for COVID-19. The plaintiff had registered trademark for a chemical product bearing the same name. The High Court passed an order of temporary injunction to restrain the defendant from the use of the trademark as the case was made out in the favor of the plaintiff. So, in this case, the temporary injunction was granted, wherein the plaintiff, which is the Arudra Engineers Private Limited, had the trademark of the medicine called Coronil, and Patanjali Ayurved Limited was restrained to use that word, that trademark for their tablets, because it had infringed the trademark. So temporary injunction here was granted without deciding the final rights. But since the case was made out by the plaintiff, the court had granted the injunction. In another case of Jagjit Singh Khanna versus Rakhal Das Malik, the Calcutta High Court passed an interim or temporary injunction that consists of two stages of interim and ad interim injunctions. Rule 1 and Rule 2 of Order 39 do not use the words interim or ad interim. These merely indicate the stage at which orders are passed. The only difference between interim and ad interim injunctions lies in the period for which they operate and the stage at which they are passed. I'll explain it to you in detail as to what are the interim and ad interim injunctions. So the Bombay High Court has differentiated between the ad interim and interim injunction. I will quickly explain. An interim order operates only till the hearing of the application. As I said, the injunction application or suit is filed. The ad interim order is operates for a limited period. For example, it is possible that in a given case, at the time of institution of the suit, the plaintiff does not make an application for an order of interim injunction, as he feels no necessity, in which case only summons of the suit is issued to the defendant. During the pendency of the suit, a contingency may arise requiring the plaintiff to apply for an injunction. When such an application is made and when the defendant is present and seeks time to file a reply, the court may pass an ad interim order of injunction pending reply of the defendant. In some cases, even after the reply is filed by the defendants, the court may grant an ad interim order of injunction if it does not have time to hear the matter and feels that it is necessary to grant injunction pending hearing to protect the plaintiff pending hearing of the application. Thus, ad interim order of injunction may be ex parte or may be passed even in the presence of the defendants. Now, I'll explain this. The ad interim orders or injunction operates for a very limited period. Supposingly, we have instituted a case, a proceeding, the plaintiff has instituted, and he felt that, okay, right now I would not want any stay order or I don't want any restraint order, and let the notice be issued to the defendant, the other side, right? And the defendant may appear, and then right now it is not incumbent or it is not necessary that the court may pass any order. But after the institution of suit, the defendant appears. Immediately, there is a situation which is created wherein it is imperative that the injunction order or ad interim injunction order be granted. If it is not granted, it would cause loss to the plaintiff. So at that time, without even hearing the defendant, the court may pass an ad interim order. Ad interim order means for a very short period, and until the other side is heard, the court would restrain. No, please stop here. Because if you do not stop here, this would make the injunction application infructuous. That means that then there would be no point in arguing and hearing the main application. So right now you restrain, or the status quo order be maintained, status quo of the property or the rights be maintained, and then we would hear the injunction application or suit later on. So ad interim is a stay which is granted for a short period. It may also happen that when the defendant appears or the other side appears in the court, they may ask for time to file the reply to the plaint or the petition which is filed by the plaintiff. So at that time also, the court may say that, you are asking for time. And then, if I grant you time, the rights of the plaintiff or the petitioner would be infringed in the meantime. So until you file the reply and the case or the injunction application is heard, please stop here. The restraint order is passed. So that kind of orders are ad interim orders. Now, what are the interim orders? Interim order usually remains in force for the whole period of the suit unless varied under Rule 4 or set aside in appeal. The interim orders are basically the orders which are passed after hearing both the sides, that is the plaintiff and the defendant, and they are continued for the entire period until the suit is pending or the suit is finally decided. So this is the difference between ad interim and interim orders. So what is a perpetual injunction? Perpetual injunction under section 37(2) states that a perpetual injunction can only be granted by the decree made at hearing and upon the merits of the suit. We are talking about permanent injunction suit and temporary injunction suit. So what is a permanent injunction or a perpetual injunction? Can only be granted by a decree. Decree means the final order, that is the judgment, which would be finally passed by the court when it has heard the case on merits, right? And it has heard both the sides on merits, and the final order is passed, which finally restrains the defendant by way of a perpetual injunction. The effect is that the defendant is thereby perpetually means permanently enjoined from the assertion of a right or from the commission of an act which would be contrary to the rights of the plaintiff. So the defendant is permanently restrained, which is affecting the equitable and legal rights of the plaintiff. So a perpetual injunction is permanent relief granted after final adjudication, means final hearing of the parties' legal rights. Such final relief can further be prohibitive or mandatory in nature. Prohibitive means you will be stopped, restrained, or mandatory means, yes, you have to do this. So there are two kinds of reliefs. One is prohibitive, means you are restrained, you are stopped, you are not to do this act. Or mandatory is you are supposed to do this act. So this is the difference of prohibitive or mandatory nature. A perpetual injunction merges into a decree. Decree means final judgment, final decision of the court. And only when the parties are heard and upon the merits of the suit. What is the merits of the suit? The pros and cons, the contentions raised by both plaintiffs and the defendants, and the facts of the case. All combined are called the merits of the suit. What is the merit? Merit means what is important in the suit. So both the sides would argue the case, and then the court would come to a conclusion by way of a judgment or a decree. The injunctions of this kind are governed by sections 38, 40, and 41 of the Specific Relief Act. In most cases, apart from seeking a relief for perpetual injunction, an application for a temporary injunction is also filed along with it. So if the suit of permanent injunction is filed, then an application for temporary injunction is also filed along with that. Why? Because perpetual injunction or mandatory order or decree would be passed, that would, in a very late stage, that would take a lot of time to decide the case. So in the meantime, if the defendant continues to infringe the rights of the plaintiff, an order of ad-interim nature or interim nature is required to be passed by the court. So along with the application of the suit for permanent injunction, an application for temporary injunction is also passed. So this I will skip. What is the meaning of temporary injunction? Temporary injunction refers to a judicial intervention of maintaining a status quo. Status quo means stop. Whatever is in existence, you have to, existing situation is status quo. Existing condition is status quo of a thing applied by either of the parties as an interim relief during the pendency of the proceedings of the case. It is an order of the court that restrains prohibitory injunction or requires a person to do a particular act, that is mandatory injunction, which I've already explained. It is in the nature of protective relief granted keeping in mind the rights of both the parties to prevent a future irreparable injury. So temporary injunctions are such as are to continue until a specific time or until the further order of the court, and they may be granted at any stage of the suit and are regulated by the Code of Civil Procedure. Now, what is the object of temporary injunction? The object of temporary injunction is to protect the plaintiff against injury by violation of his rights for which he could not be adequately compensated in damages, recoverable in action if the uncertainty were resolved in his favor at the trial. So what is the crux? The crux is the injunction is granted because there is a violation of the right of the plaintiff, right? So the rights and this cannot be compensated. Even if 10 crores, 100 crores is given, that would not compensate the plaintiff if his rights are infringed. So it cannot be adequately compensated in damages recoverable in the action. Even if the damages are granted by the court finally, then also it would not be enough for the protection of the rights of the plaintiff. So this is the object of temporary injunction. The temporary injunction can also be granted if the person seeking injunction has concluded right. He has right capable of being enforced by way of injunction. So what are the ingredients when the court grants temporary injunction? You must understand it is an equitable relief. The suits for injunctions are equitable relief granted by the courts. The equity means it is discretion of the court to grant you relief, right? So what are the three factors which are important to grant an injunction in favor of the person who approaches the court? The three factors are: there is a prima facie case. Number two, the balance of convenience is in favor of the plaintiff, and there is an irreparable loss. Means the loss which is being caused by that infringement is irreparable. It would not bring back the same situation as it is today when the case is filed, right? So it would be late for the court to decide the rights finally, and when it would be decided, that would cause a loss which would be irreparable. In the case of Dalpat Kumar versus Prahlad Singh, the apex court explained these three factors as follows. There is a serious disputed question to be tried in the court, and that an act on the facts before the court, there is probability his being entitled to the relief asked by the plaintiff or the defendant. The court's interference is necessary to protect the party from this species of injury. In other words, irreparable injury or danger would ensure before the legal right would be established at trial, and that the comparative hardship on mischief or inconvenience which is likely to occur from withholding the injunction will be greater than that would be likely acted from granting it. So what is prima facie case? Prima facie case does not mean that the plaintiff should have a 100% case, right? Prima facie case is the case as it appears, right? So it is called a prima facie case. It need not be a case the court would understand that no, this right is absolutely final. You don't have to plead before the court that no, before granting an injunction, the court may not take it as if your right is final, because that is going to take some time to decide. So it does not mean the plaintiff should have a 100% case. It may be like the court should feel that, yeah, there is a prima facie case. there is apparently it feels that the right of the plaintiff is infringed, which will in all probability succeed in trial. Prima facie case means that the contentions which the plaintiff is raising require consideration in merit and are not liable to be rejected summarily, right? The burden is on the plaintiff to convince the court that there is a prima facie case by furnishing sufficient evidence or otherwise in his favor. In the case of Kanshinath Samston versus Srimad Sudhindra Tirtha Swami, the Supreme Court held that prima facie case must precede an order of injunction. Only if there's a prima facie case, then the court will move ahead to examine other factors. If the prima facie case is not made out, the applicant is not entitled to a temporary injunction. Now, what is the balance of convenience? That is the second ingredient. To see balance of convenience, it is necessary to compare the case of the parties, right? You have seen that in the Temple of Justice, there is a lady which is holding balance, a tarazu, wherein the court has to find the strike a balance between the rights of the two parties, right? So it is necessary to compare the rights of the parties by the court. The comparative mischief or inconvenience, that is mischief. Who is causing more mischief? Whether the plaintiff is mischievous, he has come to the court, or the defendant is more mischievous. Or the third is inconvenience. Which is causing more inconvenience? Whether it is causing more inconvenience to the plaintiff, or it would cause, if the court passes an order, would cause more inconvenience to the defendant. So, which is likely to sue from withholding the injunction will be greater than which is likely to arrive from granting it. The balance of convenience must be in the favor of the applicant, that means the plaintiff. Before granting an order of injunction, the court must be satisfied that the mischief, hardship, or inconvenience which is likely to be caused on refusal to the plaintiff is greater than that which is likely to be caused to the opposite party by granting it. Right? So the third is irreparable loss. The third ingredient when the court grants injunction is see whether there is an irreparable loss caused to the applicant or the petitioner. The applicant must further satisfy the court that there is a possibility of irreparable harm, a harm which cannot be repaired to him, and that if an order of temporary injunction is not issued, will injury him. Irreparable harm may refer to damages that may not be possible to be compensated in pecuniary terms, right? The damage is so much so that even if the court grants the cost or compensation is granted, it would not be compensated in form of money. So in American Cyanamid Company versus Ethicon Limited, the court has rightly pronounced the principle of irreparable harm as follows. If damaged in measure recoverable at common law would be an adequate remedy and the defendant would be in financial position to pay them, no interlocutory injunction should normally be granted. However, strong the plaintiff's claim appeared to be at that stage. If, on the other hand, damages would not provide an adequate remedy for the plaintiff in the event of his succeeding at the trial, the court should then consider it as irreparable harm. It must be noted that the expression irreparable injury does not mean that there should be no possibility of repairing the injury. It only means that there exists no specific or fixed pecuniary standard for measuring damages inflicted. However, a mere difficulty in proving injury does not establish irreparable injury. Now, I hope I'm clear with this, that what is an irreparable loss. So how long the temporary injunction lasts? The validity of temporary injunction depends on the type of injunction which is granted by the court. For example, if the injunction is granted pendentilite, means during the pendency of the suit, it will be valid till the proceedings of the case is disposed of or it is finally decided. If the suit is dismissed, the injunction is also vacated. If the plaintiff is not able to prove his case, the injunction is automatically vacated, whatever is granted during the period of pendency of the suit. If the suit is of permanent injunction, a temporary injunction made by the court is made perpetual or permanent as part of a decree passed by the court. So what are the necessary contents of the application for a temporary injunction? If you are drafting an application for temporary injunction, so also as that of a permanent injunction, what are the necessary contents which are required to be present? Number one, the court's place of sitting or jurisdiction and the name of the judge. Name of the judge means whether it is a civil judge, junior division, senior division, like that you describe what is the court in which the application is you are filing. Number two, civil suit number and the year in the prescribed manner. Civil suit number generally is given by the registry. So what we only mention is regular civil suit or commercial suit number dash of the year in which it is filed. Subsequently, the registry gives the number of that suit, right, as per the registered suits which are already filed previously in the court. The names of the parties to the suit should be properly mentioned as plaintiffs and defendants. The name has to be there. I will take you to the sample applications later on as to how they are filed, how they are drafted. A clear mention of the provision under which the suit has been filed. I have mentioned various provisions under the Specific Relief Act. I have also mentioned provisions under the CPC in which the temporary injunction application is filed, the suit for permanent injunction is filed. So your application or the suit must mention as to what are the provision. It is very important. You know, when you are going to the court, there are provisions which are available in the court that would define as to under which provision you have filed the application or the suit before the court of law, right? A clear mention of the purpose or the cause that has led to the filing of the suit. So the cause, has to be mentioned, why you have come. Unless you have any cause, there is no point the court is going to understand as to why you have come and what kind of relief you are seeking from the court. So you have to mention that this is the cause and this is how I have come to the court to seek the injunction from the court. A proper description of the disputed property, that is mapping the ancestry of the property, etc. Right? You have to describe, if the suit is filed, there is a schedule which has to be annexed that would enjoin the proper description of the property. If somebody is throwing you out of the property, you have to describe that this is the property I'm staying. Somebody is trespassed in your property, you have to describe that this is the property for which I'm holding the title. So the clear description of the property has to be mentioned. The claim of events that led to the filing of the suit. Number one, the claim of the events. What is that? The facts of the case. You have the list of events. You mention the events date-wise. That on this date, I had purchased the property. I became the title owner of the property. Number two, I started residing in that property from so and so date. Number three, the defendant encroached my property on this date. There is a series of events which takes place in formulating a case before the court. So you have to first draft the list of events, what events have taken place, and then put that facts into the case, which has compelled you to file the suit. Right? The cause is there, the facts, the narration, the story has to be there, that this is how I have come to this court because these events have taken place. The facts are the reason that bring out a prima facie case pertaining to grant of injunction. So prima facie case has to be made out, stating that this is the right. So the court, by just looking at it, not necessarily after hearing the parties or deciding or going through the documents, going through the contentions, even without that, the court should feel that, yes, this person has a right, there is a prima facie case, and it has, which may likely to be, decided in his favor subsequently after it is heard. So prima facie case, if the court is satisfied, you have to give the reasons that why it is a prima facie case. Then why the balance of convenience is in your favor and as compared to the convenience of the defendant. The convenience to the petitioner, if temporary injunction is refused, would be balanced and compared with that of the opposite party, if it is granted. Then you have to mention about the irreparable injury that would be caused if the injunction isn't allowed. You have to also mention in the application that, sir, if this is the irreparable injury, even if this court grants me 10 lakh of rupees as compensation, this injury is not going to be compensated in terms of money, right? So it is going to be an irreparable injury unless this stay is granted or injunction order is allowed. The brief pair mentioning the cause of action, the plaintiff desires or is prescribed in the procedural code, right? There has to be a prayer clause. A schedule containing all the required documents to substantiate the facts mentioned in the application, and then the affidavit. I have got some sample application which I have forwarded already. Probably they would be sent to the participant on, but I will also take you to those applications, to those drafts as to how they are prepared, how the suits are prepared, how they are drafted. Now, what are the common mistakes which we all do while drafting the suit for injunction or the application? There is always a negligence in mentioning the names of the parties and the court. So one has to be very careful in mentioning the name of the parties, which are the parties which have to be put as plaintiffs, and what are the parties which are put in the cause title as defendants, because we are seeking injunction against the defendant. So who should be made the party as defendant against whom we are seeking an injunction? Wrong usage of words, punctuations, and faulty grammar. It's okay, one need not be very good at the language so far as English is concerned, because we all come from a background where we have our mother tongues, where we are using vernacular language in the courts below. So not necessarily if you may be perfect in using punctuations and faulty grammar, but it should not misinterpret or mislead the court in understanding the case. You may not use, because why punctuations and words are important, because the court has to have the clarity of what you are asking for or what you want from the court. And what are the facts? If there is a faulty grammar, there is a misunderstanding on the part of the court, then you definitely are not going to get the result, which is in the form of injunction. Not substantiating the facts with enough documents of proof. You have to substantiate. If you have a case, if you have a title in your favor about the property, then you must substantiate it with the document. You have to have a sale deed to support that, yes, I am holding this right over the property because of this sale deed, because of this document in which it is clearly shown that I have purchased the property on this and this date, right? Using legalese instead of simple language. You are not supposed to use a very flowery language. It is good to use a simple English or simple language so far as drafting of the cases are concerned. Not clearly establishing or fulfilling the three basic principles. As I said, you have to be very clear on three basic principles, three ingredients in the suits for injunctions, application for injunctions, that is prima facie case, the balance of inconvenience, and the irreparable damage. Through proper reasoning, you have to give your reasoning as to why you would want to have an injunction. Usage of unclear language in prayer. You see, every court, before reading the case goes to the prayer. Number one, the court, we as lawyers concentrate on the contentions, on the facts of the case. But court is the authority which has to decide, which has to grant your prayer. So what it will first see, what the court first sees is, what are you asking from them? You pray before the court that please give us this, please give us the heaven, please give us this. So court has to see whether I can grant that relief or not, whether the plaintiff is asking something which cannot be granted. So it has to be very clear prayer before the court so that the court is able to understand and grant that relief to you, right? Faulty drafting of affidavit. The affidavit is something which you are writing on oath. Something you are, if you make a false assertion, if you make a false statement in your affidavit, then you would be held for perjury. It is a crime to narrate false statements before the court. And if you mislead the court, misrepresent the court, suppress the facts, the court may not grant you relief, or it may award cost in favor of the defendant also, right? So you have to be very clear as to how you have to draft the affidavit. Then improper attachment of the schedule. The prayer has to be there. You have to see that proper schedule is of the prayer. Proper schedule is drafted of the property, right? If the property is not described properly, in many cases, court would refuse to grant you relief. What are the tips of drafting good application? The claims as mentioned in the application should be well substantiated with facts and documents. The facts have to be clear. Your story has to be very clear to the court. It has to be narrated properly. The language has to be very that something should be easily understood by the court while reading. The court has about 100-200 cases every day which they have to read, and if the language is not clear, the court would be very confused as to what is he asking for. So you need not have a very flowery language or legalese language before the court. It has to be very simple language which the court understands. So always make sure using simple terms or avoid using legalese and flowery language. Familiarity with the legal element is like having in possession a map of an unexplored island. So if you are a legal, if you know the concepts of law clearly as to how you have to use the legal language or the concepts or the principles, then you have all the mapping means. If you go to any island which is unknown to you and you have the map, that means you know the road, you know what you have to, which path you have to take and how you have to go about in your case. The language of your affidavit should be sharply directed towards the other party. You see, if you're making an assertion, it should show to the court that no, this is the clear violation of your rights by the defendant. So it has been put forward by the plaintiff, then it should be exhaustive and attack the defendant, right? So it should attack the defendant in a right way, that this is where the defendant is wrongfully infringing your rights. If you are the defending party, then make sure you answer to each and every point made out in plaintiff's affidavit and counter it with well-substantiated facts. If you are a defendant in the case, then you must answer each and every. I've had a session of drafting a written statement. The written statement should have everything that would counter the assertion or allegations made by the plaintiff, right? So these are the tips of drafting a good application. What is the principles of equity? I tell you, I was telling you about that injunction is a equitable right, equitable relief, which is granted by the court. So what is this principles of equity, which is behind the mind of the court? What is it? So principles of equity is the party who seeks equity must come with clean hands. So somebody who is approaching the court cannot state facts or misrepresent the court. It has to have clean hand, means the plaintiff cannot be somebody who is himself infringing the rights of the defendant, who is a wrongdoer, and then claiming the relief. The court will see your conduct, the conduct of the plaintiff, as to whether he is approaching with clean hands, whether he is the person who is not a culprit, whether he is the person who is not the wrongdoer. So you have to be yourself a clean person before you are asking an equitable relief. It is a discretionary relief based on equity given to the party who approaches the court. The party who suppressed the material fact from the court does not deserve to get any discretionary relief, which much less an order of temporary injunction. What is suppression of material facts? Material fact is those facts which are necessarily to be brought before the court. When you're narrating a story or narrating the facts of the case, it should have everything. Something which is even going against you must be pleaded in your application or suit. You cannot suppress something which may come out by way of a reply by the defendant. It has to be something which you yourself has to mention in the suit, even if that is going against the against your case. You see, you would be a good craftsman. You would be able to draft the application in such a way wherein you would definitely learn to draft your application in a manner wherein there is no suppression of material fact, and yet it is narrated in a fashion that it would appear to the court that you are the person whose rights are infringed and the defendant is the culprit, he is the wrongdoer. So that would be come out, maybe out of experience maybe out of learning drafting, your practice of drafting an application. So that would gradually come out. But the moment the court feels that you have suppressed the material fact, then of course you would not get the relief. The party who seeks equity must do equity. Delay defeats equity. If you had a right for which you were to appear before the court, then you must immediately approach the court. It is not that after 3-4 years, your right was infringed and you were sleeping over it, and then you're approaching the court. That the court would not like it. The court would not grant you any relief if you are approaching the court after delay, right? So delay defeats equity is very much important while deciding the ad interim ex parte injunction. So you have to give reasons if there is a delay. If suppose your client is not able to come, then you have to either file an application for condonation of delay, or you have to pray it in your suit that why you have caused the delay in approaching the court. There has to be sufficient cause explained in your suit. The party cannot take disadvantage of his own wrong is also very important. You are you can't take advantage. You are a wrongdoer. You cannot take advantage of your wrongdoing. Where there is a right, there is a remedy. The very much useful while invoking Section 151 of CPC of inherent power of the court. Where permanent injunction has not been sought for in the suit itself, no interim preventive injunction can be granted. If you are not seeking a permanent injunction, then definitely the court would refuse to give you the interim injunction. So it all depends how you have made the prayer. So this is the kind of format which you need to have. Prohibitive and mandatory injunctions I've already explained. Perpetual injunction I've already explained. So these are some of the cases there. When a perpetual injunction can be granted, there must be a breach of an obligation or infringement of a legal right. The possession must be lawful one, right? Then there are other when the perpetual, I'll give you some more examples. When there is a juridical possession also can be protected. The continuance of possession by the lessee without the consent of the lessor may not be lawful possession, but it is a juridical possession which can be protected against the high-handed acts of forcible dispossession, right? That can also, whether symbolic delivery is sufficient to sustain an action for injunction, where the defendants admitted the title of the plaintiff to this scheduled property, and the court also find that plaintiff had taken symbolical possession of the scheduled property. In execution proceeding, the court in a suit for permanent injunction should have proceeded to examine whether the plaintiff was in actual possession of the suit land on the date of suit, and if the court finds that plaintiff was in possession of suit, it cannot reject his prayer for permanent injunction, since even if it was case of symbolic delivery of possession, symbolic delivery amounts to actual delivery. So even if there is a symbolic possession taken by the plaintiff, the court can grant permanent injunction. Suit for injunction by a person in possession without title, like possession, a person in possession can be evicted only by due process of law, and hence even a rightful owner cannot eject him by force. If the rightful owner threatens his peaceful possession, he can approach courts of law and pray for the equitable relief of injunction to protect the injunction, injunction against the lessee, injunction against the lesser, injunction in case of co-owners, where co-owner intends to carry on with the material change in the user of joint property without the consent of the other co-owner, he may restrain the other from carrying on with such operations. Injunctions in case of nuisance. A relief on injunction can be claimed to stop nuisance if in a noisy locality there is a substantial addition to such noise by introduction of some machine or instrument or some performance of premises of the defendant which affects the physical discomforts of the members or occupants of the plaintiff's house. Injunction in case of easementary rights, right? Injunction against a trustee making unauthorized changes in the case of a trust property affecting the very character of the institution will be restrained by means of an injunction. Injunction to prevent waste. While granting an injunction on the ground of waste and whether the court has to consider the nature and also content of and also the extent of waste and whether granting injunction is necessary to prevent such waste. So, when the perpetual injunction can be refused, there is a provision when it can be refused to restrain any person from prosecuting a judicial proceeding pending at the institution of the suit in which the injunction is sought unless such restraint is necessary to prevent multiplicity of proceedings. If there is a multiplicity of proceedings, that there are several cases filed, then the court may think of granting injunction, but merely to stop somebody from prosecuting a judicial proceeding, the injunction cannot be granted. So it will be refused. To restrain any person from instituting or prosecuting any proceeding in a court, not subordinate court to that from which the injunction is sought. So something which can be done by the higher court, the lower court definitely cannot grant any injunction. To restrain any person from applying to any legislative body, to restrain any person from instituting or prosecuting any proceeding in criminal matter. These are the cases where the injunction is refused. Continuing, breach in which the plaintiff has acquiesced, when equally efficacious relief can certainly be granted by other usual mode of proceedings. Injunction cannot be granted in contracts which cannot be specifically enforced. This is clear from the reading of section 14(1) of Specific Relief Act. Contracts not specifically enforceable are a contract for non-performance of which compensation in money is an adequate relief, a contract which runs into such minute or numerous details or which is so dependent on personal qualifications or violations of the parties or otherwise from its nature. A contract which is in nature determinable, or contract the performance of which involves the performance of continuous duty. So these are the incidents where the injunction can be refused. Now, what are the interlocutory applications? The interlocutory applications or interlocutory has not been defined anywhere in the Code of Civil Procedure, but the Civil Rules of Practice defines the word interlocutory application in Rule 2J as an application to the suit to the court in any suit, appeal, or proceeding already instituted in such court other than the proceeding for execution of a decree or order. The words interlocutory application and interlocutory petition are synonymous. The orders that come to be passed in these applications are interlocutory orders. They are of various kinds, some like orders of attachment, appointment of receivers, appointment of commissioners, to preserve the status quo of the litigation, and are some to ensure the just, smooth, orderly, and expeditious disposal of the suit. Thank you very much. Now, I would just take you quickly to the sample applications. If let me share that. I think these would be shared with you. So you see that this is the kind of sample suits which you are required to draft. First, you have to mention the court. Here I've mentioned District Court Dwarka in New Delhi. Then civil suit number -23. This is the usual practice. This number is granted by the registry of the court. In the matter between the parties ABC, who's the plaintiff, his name and addresses. If there are more plaintiffs, then you have to describe the name. If they are co-owners of the property, then all of them who are the owners of the property for which you are seeking relief would become the plaintiffs. Then the defendants are those parties against whom the relief is taken. Then, as I said, you have to have the list of dates and events. This is how you build up a story that so-and-so happened this, the defendant started raising construction and encroached upon the land of the plaintiff. So the dates are very important. Anybody who comes to you, you have to take the story, you have to take the facts properly and note down the dates as to how and when the events have taken place. So when you are making an application or drafting a suit or a petition, the list of events has to be mentioned so that the court understands that this is how things have happened and this is how you are or your client has compelled to approach this honorable court. So then I said, this is the party, this is civil suit seeking permanent, prohibitory and mandatory injunction against the defendant under section 37 and 39 of the Specific Relief Act. Description of the parties. Firstly, you have to mention then what so-and-so owner, who's why, what is the status of the party? The plaintiff is the owner. The defendant is the owner in possession of so-and-so, so-and-so. That means the adjoining property. Probably that person has encroached on your property, right? So what is the relationship? The plaintiff and defendant have been neighbors since 1967, as they live in the same residential area, that the plaintiff and defendant share an otherwise friendly, cordial relationship with one another. Brief facts. So this is how you have to narrate the facts, right? What is the value of the suit? The valuation, if you are seeking pecuniary compensation, that then there is a schedule of court fees which you have to affix along with this suit. But for general relief, there is a fixed valuation of the suit in which you are seeking the relief. The present civil suit is being filed in a bona fide manner and in the interest of law. Is non-commercial suit, the balance of convenience, you have to give the reasons, prima facie case, suffer irreparable loss, all these factors. Plaintiff does not have file similar civil suit. You cannot file suits in two courts simultaneously. So you have to give a declaration that you have not filed a similar suit seeking same prayers in another court of law, in another territorial jurisdiction. That the suit is maintainable in the eyes of law. The annexure are the true copies. The suit filed period is under limitation. You cannot, there are limitations provided under the Limitation Act. You have to mention that this is being filed within 3 years of the limitation period in which you can file the suit, right? Then the prayer clause, prohibitory injunction, mandatory injunction, etc. Remove illegal and unauthorized construction over the suit. This is the prayer you have to make, right? Then this is the affidavit, same affidavit narrating the same facts, verification, then application for interim injunction, right? Or prohibitory injunction under Order 39, Rule 1 and 2. So this is how you draft an application. So again, an affidavit in support of the application has to be same facts, what is narrated in the application has to be placed by way of an affidavit. Thank you very much.
Thank you so much, sir. I express my deep sense of gratitude to Honorable Advocate Nagesh Sood, sir, for accepting our invitation and for dealing with such a complicated topic in a commendable way. Thank you for always being there for legal expatiate. I also thank all the participants for evincing interest in today's session. Thank you so much, one and all. Thank you so much, sir.
Thank you very much. You've been very kind, and I hope that